This chapter mainly discusses three types of improper behaviors: market misconduct, unsolicited calls, and improper trading practices. Among them, those related to violations of the Securities and Futures Ordinance are market misconduct, unsolicited calls, and those related to violations of the SFC's code are improper trading practices. What is market misconduct? Market misconduct refers to dishonest, unfair, or fraudulent practices involving trading in securities and futures contracts. There are three main elements to constitute market misconduct. Firstly, the misconduct usually involves recognized markets, i.e., exchanges, including stocks and futures contracts on the SEC, Stock Exchange of Hong Kong, and the HKSI, Hong Kong Futures Exchange. Secondly, these actions can lead to losses or improper benefits. Thirdly, these market misconducts must be intentional, i.e., they must be deliberate, planned, and premeditated to be considered intentional. If it is unintentional, careless, or accidental, it is not considered intentional. Why is intention so important? Because in the context of Hong Kong law, determining whether there is intention is crucial. It may determine the severity of the guilt and the application of different legal provisions. So, what if you are always careless or do not take preventive measures for a long time? This kind of long-term negligence or inaction, from a legal perspective, will also be considered intentional, okay? If market misconduct is committed, how does Hong Kong law handle it? Let's first talk about the dual-track system. What does dual-track system mean? The dual-track system, also known as the dual approach, allows for the same market misconduct to be dealt with in two different legal ways. One is the civil route and the other is the criminal route. The SFC can choose one of these ways to handle cases of market misconduct. If the civil route is chosen, the case will be adjudicated by the Market Misconduct Tribunal, and if the criminal route is chosen, it will be handled by the criminal court. However, for the same person's misconduct in the same market, the SFC can only choose one of the ways to report. In other words, if you are found to have market misconduct, the SFC can either sue you civilly or criminally. But it cannot sue you both civilly and criminally at the same time. Okay, so who decides whether to handle it in a civil or criminal way? After the SFC investigates the misconduct, it will consult the opinion of the Secretary for Justice, and the Secretary for Justice will finally determine whether to handle it in a civil or criminal way, okay? So what's the difference between the civil and criminal routes? Actually, it's quite simple. The most direct difference is, in civil cases you definitely won't go to jail, while in criminal cases, there is a chance you might go to jail. It's not that you will go to jail, just that there is this possibility, okay? Please note, as we have discussed in our previous lessons, regarding the standard of proof, i.e. the required evidence, the requirement for the criminal route needs to prove beyond reasonable doubt. The standard is higher and stricter, while the civil route uses the civil standard. Balance of probabilities. The standard is lower and relatively relaxed. Clear? So who will sue you? Criminal cases are brought by the Department of Justice to the court, while civil cases are brought by the SFC, Securities and Futures Commission, to the MMT, Market Misconduct Tribunal. In terms of punishment, the criminal route can sentence you to jail, so the punishment is heavier, and all the consequences that the civil route can punish you for. On the civil side, there will absolutely be no jail sentence, more towards some remedial measures. There may be fines, public reprimand, compensation, suspension of trading, revocation of license, so the judgment will be relatively lighter, but absolutely no jail, okay? As for investors who lose money due to market misconduct, regardless of whether the market misconduct charge is ultimately established, they can bring a private civil lawsuit to the court. This private civil lawsuit is separate from the SFC's actions, the SFC's investigation, the Market Misconduct Tribunal's inquiry, or the criminal court's trial, will not affect the investor's right to bring a private civil lawsuit. What kind of market misconduct will be tested in the exam? There are mainly the following types. First, insider dealing. Second, false trading. Third, price rigging. Fourth, disclosure of information about prohibited transactions. Fifth, disclosure of false and misleading information inducing transactions. Sixth, stock market manipulation. Seventh, fraud. So why do we need to deal with these market misconducts? As we have mentioned before, one of the main objectives of the SFC is to maintain and promote the fairness, efficiency, competitiveness, transparency, and order of the securities and futures markets. Market misconduct can not only potentially cause undue losses to investors, but also disrupt the normal order of the market. Reducing such misconduct and punishing offenders can not only better protect investors, but also strengthen public confidence in the market. Okay, next, let's introduce the 7 types of market misconduct mentioned above. The first one, insider dealing. So what is insider dealing? There are actually 2 types of insider dealing. One is called dealing, and the other is called tipping off. For example, after you know the inside information of a listed corporation, you go to trade the listed securities or derivatives of this corporation. This is insider dealing. Or you tell this inside information to others, induce others, let them trade. This is also insider dealing. Or you tell this inside information to others, you clearly know that this person may trade in the future, but you still tell them. These are all insider dealing. So what exactly is insider information, since it's called insider? The most important thing is that it's not known to the general public. Secondly, it can affect the price of listed securities. That is, the dissemination of this information can affect the price of listed securities. Thirdly, this information is important. For example, if a glass door of a listed company, Vitasoy, is broken, or if one of their delivery trucks is broken, these things will affect Vitasoy's business. Although the public doesn't know about it, will these things affect Vitasoy's stock price? How much impact do they have on Vitasoy's stock price? Well, generally speaking, there is not much impact. So, are these considered insider information? No. Okay, if I find that the McDonald's I go to every day is not doing well, almost no one goes there except me. The staff are swatting flies every day, so I think this McDonald's may be about to close down soon. So I know this. Do other people have a chance to know this? Actually, anyone who has passed by or been to this McDonald's has a chance to know. Although poor business is a piece of information that can affect stock prices, everyone knows it, so this is not considered insider information, okay? So what exactly is insider information? Since it's called insider, the most important thing is that it's not known to the general public. Secondly, it can affect the price of listed securities. That is, the dissemination of this information can affect the price of listed securities. Thirdly, this information is important. For example, if a glass door of a listed company, Vitasoy, is broken, or if one of their delivery trucks is broken, these things will affect Vitasoy's business. Although the public doesn't know about it, will these things affect Vitasoy's stock price? How much impact do they have on Vitasoy's stock price? Well, generally speaking, there is not much impact. So, are these considered insider information? No. Okay? If I find that the McDonald's I go to every day is not doing well, almost no one goes there except me. The staff are swatting flies every day, so I think this McDonald's may be about to close down soon. So I know this. Do other people have a chance to know this? Actually, anyone who has passed by or been to this McDonald's has a chance to know. Although poor business is a piece of information that can affect stock prices, everyone knows it, so this is not considered insider information, okay? In addition, inside information must come from the following people, as well as their spouses, parents, children, or cohabitants, to be considered inside information. Who are these people? Remember. First, officers of the listed company, such as directors, company secretaries, responsible officers, etc. Second, substantial shareholders of the listed company. Third, persons preparing to acquire the listed company. Fourth, professionals of the listed company, such as lawyers, accountants, auditors, etc. And one category that you might not think of is the major trading counterparts of the listed company, such as suppliers, clients, etc. You might ask, why can major clients and suppliers also be sources of inside information? Let me give you an example. Suppose there is a supplier of Vitasoy who specializes in providing Vitasoy with glass bottles and soybeans. Suddenly, they know that Vitasoy may stop producing soy milk next year, and soy milk is a large part of Vitasoy, which affects the stock price. This news is not yet known to the public, but the supplier already knows. Because Vitasoy won't renew the order for glass bottles and soybeans with them. If they tell you, and then you trade this stock, it might be insider trading. Why? Because this news is not yet known to the public, it may affect the stock price, and the news comes from the supplier, so this may be inside information. If you trade using this information, it is insider trading, okay? So if someone accuses you of insider trading, can you defend yourself? Are there any situations that you can use to defend yourself? Yes, there are. First of all, very simply, there is a system called functional barriers, Chinese walls. That is, within a company, different positions and functions are separated. If a company employee does not have access to inside information when trading, they will not be prosecuted for insider trading. For example, there is an accounting firm that audits Vitasoy. Through the audit, they found that Vitasoy's business will be very good next year. At this time, the cleaning lady of this accounting firm just bought a lot of Vitasoy stocks at the same time. But she only does cleaning and knows nothing about Vitasoy's financial situation. She buys and sells stocks entirely on her own volition. If someone says, hey, your firm is auditing Vitasoy, and your staff bought Vitasoy stock, this must be insider trading. Then the cleaning lady can say, hey, no, it has nothing to do with me, because I can't access this information, I just do the cleaning. This is a valid defense. Okay, what if I have inside information and tip off my friends? Merely having and sharing inside information isn't illegal in itself. However, the issue arises when you act on that information or encourage others to deal. For example, telling a friend that a company is undergoing financial troubles and laying off many employees is one thing. However, you're stepping into dangerous territory if you advise your friend to sell the company's stock because of that inside information. This could be seen as insider dealing, especially if you're somehow connected to that company or you've received this information from someone who is. Why? Because you'd be guiding your friend to make dealing decisions based on confidential, non-public information. Can you defend yourself if someone accuses you of insider trading? What defenses do you have? Indeed, there are. Firstly, there is the Chinese wall defense. Corporations often establish effective separation systems between employees engaged in different business activities to prevent information leaks. For instance, if an accounting firm is auditing Vitasoy and learns that Vitasoy is projected to excel in the upcoming year, and the firm's cleaner, who does not know of this, decides to buy Vitasoy shares, she would not be liable for insider dealing. Her defense would be her lack of access to such inside information due to her role solely involving cleaning. Secondly, there's the excluded purpose defense. This means that even if you possess inside information, you will not be charged with the offense of insider dealing if your purpose for dealing was not to profit or prevent loss from that knowledge. Imagine you're a bank manager for Vitasoy, and you know they plan to borrow significant capital for expansion, which could potentially raise the stock price. If a client, Miss Lee, instructs you to buy a large amount of Vitasoy shares for her, you're merely fulfilling your duty to her without any intention of using the inside information for personal profit. Therefore, your actions wouldn't qualify as insider dealing. Thirdly, we have the market contract defense. This applies when you're obligated to fulfill a predetermined market contract. Let's say there's a fund in the market called the Tracker Fund of Hong Kong that consistently buys and sells HSBC shares daily as part of its strategy, regardless of market conditions. If the fund manager, Mr. Lee, is privy to information suggesting HSBC might underperform in the coming year but continues dealing as per the fund's strategy, he's not exploiting inside information. Instead, he's merely adhering to the fund's strategy. Next, there's the defense involving the dealing of a connected person. Both parties in dealing are aware that one party is a connected person. Suppose Mr. Chung is a director at a major company, ABC, and he's aware that the company is about to announce good news that could significantly boost its share price. At this point, his friend Miss Lee wants to buy ABC shares from him. While Miss Lee knows Mr. Chung is a director at ABC, Mr. Chung hasn't shared any insider information with her. Thus, it would not be considered insider dealing. Lastly, the fifth one is about the exercise of an existing right. What does that mean? It means exercising a right you already have, not a newly acquired one. For instance, Mr. Chung, an employee of Vitasoy, receives stock options from his company annually. One day, he decided to exercise these options into shares. Even if he knows good news that could enhance the stock price, this action would not be considered insider dealing since the right to exercise was acquired before he became aware of the inside information. In summary, if the dealing doesn't rely on insider information to gain an unfair advantage, it would not be classified as insider dealing. All right, let's delve into false trading. This concept often pops up in exams. Many students get it wrong. So, why is it so challenging? A common misconception equates false trading with fake transactions, leading to the belief that the transactions are inauthentic. That's not the case. In fact, transactions under false trading are very much real. They are genuine whether it's shares, bonds, or any other financial instrument. Moreover, these transactions occur within recognized platforms or exchanges. In other words, they are real transactions involving actual financial instruments in the market. Then, why call it
false trading?
The answer lies in the intention. The primary goal of these transactions is to create a false or misleading appearance of active trading or the market or the price. Is the intent necessary? Absolutely. Intent is crucial in determining market misconduct. Only actions taken with deliberate intent are classified as market misconduct. False trading can be divided into wash trade and matched order. In a wash trade, financial instruments are used in transactions that genuinely occur within an exchange. But here's the catch: the buyer and seller are essentially the same entity, with no change in beneficial ownership. They merely execute the transaction through different brokers. So, what about matched orders? Imagine if I were to buy a security and then immediately sell it to someone else. This transaction with the second person doesn't truly reflect market supply and demand. Instead, it's designed to create a false appearance of active trading or the price. To sum it up, always bear in mind that the purpose of false trading is all about creating a false appearance. What is price rigging? Price rigging involves executing fictitious or artificial trades, like wash trades, intending to control the price of securities or futures contracts. Someone might deliberately buy or sell securities before the market closes to influence a security's price. Sound a bit like false trading, where someone creates a false price appearance, right? Exactly. While they might seem similar, their objectives can differ. Consider this: if a client says, "Mr. Chan, make some trades to bring HSBC's closing price down to 35 Hong Kong dollars, that's clear-cut price rigging. But if the instruction is, "Mr. Chan, can you boost the trading volume between 36 Hong Kong dollars and 40 Hong Kong dollars? I want people to think there's significant buying in that range," which leans more towards false trading. Indeed, many acts of price rigging can overlap with false trading, which can blur the lines between them. But for your exam, remember this: price rigging focuses on controlling the price, and the intent behind it is crucial. In contrast, false trading primarily aims to create an illusion of an active market. Whether it's price rigging or false trading, both only apply to transactions made on exchange. So, what exactly is stock market manipulation? It's similar to the price rigging we previously discussed. However, the key distinction is that stock market manipulation involves multiple transactions, which could mean 2, 3, or even more. For an act to be called stock market manipulation, more than one transaction must be involved. What does it mean to disclose information about a prohibited transaction? First, let's understand what a prohibited transaction is. It refers to specific actions that constitute market misconduct. When an individual discloses, circulates, or disseminates inside information hinting that it might affect the prices of securities or futures contracts, they essentially disclose details about a prohibited transaction. Take the case of an executive named Mr. Lee. He's aware that his company is about to announce a revolutionary technology which might significantly raise the company's share price. Mr. Lee intentionally leaked this news to the media. As a result, many investors buy the shares and increase the share price. Those who bought the shares are strangers to Mr. Lee, with no beneficial connection. It's crucial to note that this doesn't fall under insider trading since Mr. Lee didn't instruct anyone to buy the shares. However, he disclosed the information to outsiders to influence the share price. This is what's called disclosing information about prohibited transactions. What is
Disclosure of false or misleading information inducing transactions?
Simply put, someone deliberately shares false information to induce transactions in securities and futures contracts. How is it different from disclosing information about prohibited trades? The key here is the nature of the information. In this case, the information is false or misleading, whereas prohibited trade information is factual. Misleading others accidentally, perhaps due to negligence, falls under civil liability. But if you knowingly or recklessly distribute false information, you could face a potential criminal offense. Lastly, printers, publishers, and media outlets won't bear legal responsibility if they merely transmit information as a communication conduit, without intent to deceive. Clear, isn't it? The market misconduct we've discussed primarily occurs within a trading exchange, but its scope goes beyond Hong Kong. The SFC has specifically outlined that the following scenarios will be considered as market misconduct. Firstly, any conduct in Hong Kong that affects overseas markets. Secondly, any conduct overseas that affects Hong Kong markets. Additionally, insider dealing in securities listed in Hong Kong or overseas securities with a dual listing in Hong Kong. In other words, whether you are attempting to influence the securities markets of other countries from Hong Kong, trying to influence Hong Kong's securities market from elsewhere, or affecting Hong Kong's market within Hong Kong itself, all are seen as breaches of market misconduct rules. As mentioned in Chapter 8, issuers or underwriters can undertake price stabilizing action during public offerings. But are these actions always regarded as market misconduct? Remember, price stabilization is not market misconduct if 1. Conducted by either the issuers or underwriters, and 2. Executed only after the initial public offering. Such exemption, known as the Safe Harbor Rules, permits specified stabilizing activities related to public offerings to be engaged in lawfully. But be aware that if underwriters and issuers engage in price stabilizing actions outside these periods, they aren't allowed and normally could be constituted as stock market manipulation, false trading, or price rigging. Let's turn to the final market misconduct type, fraud and deception. Put simply, if you engage in any fraudulent or deceptive act, employing any device, scheme, or artifice in a transaction involving securities, futures contracts, or leveraged foreign exchange trading with the intent to deceive or defraud, you're directly stepping into the territory of fraud and deception. Bear in mind that intention plays a pivotal role in determining market misconduct. Having discussed various types of market misconduct, you might wonder about their consequences. As mentioned, the SFO offers two legal routes for addressing such misconduct, civil and criminal. For civil cases, the judgment is made by the Market Misconduct Tribunal, while the criminal court decides criminal ones. Now, what's the Market Misconduct Tribunal, MMT? The MMT operates as an administrative tribunal, standing apart from the SFC, created by the SFO. Its members comprise a chairperson who is a judge and 2 other members from the business or professional sectors, all appointed by the chief executive of HKSI. While chaired by a judge, remember, the MMT isn't a court. It exclusively handles civil issues, which means it doesn't deal with criminal matters or send anyone to prison. In the proceedings, the MMT uses a balance of probabilities standard of proof, which is less stringent than that of criminal cases. Also, the MMT is not bound by the rules of evidence which apply to the courts. Therefore, it can compel and receive any evidence relevant to the proceedings. What orders can be made by the MMT? While the MMT only deals with civil cases, meaning it cannot impose imprisonment, it does have the authority to issue various orders against those found guilty of market misconduct. What are these orders? The MMT can ban an individual from trading or investing in the Hong Kong market for up to 5 years, known as a cold shoulder order. Prohibit the person from engaging in any further market misconduct. Require offenders to pay any profits they made or any losses they avoided to the government. Order the offender to cover the reasonable costs and expenses incurred by the government and the SFC. Disqualify individuals from holding office as a director, liquidator, or receiver for up to 5 years. Require the suspension or revocation of licenses for licensed persons. It's important to note that the MMT has no authority to send anyone to jail since it is a civil matter. How does the Market Misconduct Tribunal issue the orders? After the proceedings conclude, the MMT will issue a public report. This report will state whether any market misconduct has taken place, identify the person involved, and specify the amount of profit gained or loss avoided due to such misconduct. Also, the order and reasons given by the MMT for such actions will be included. How does the court determine sanctions when prosecuting a case through the criminal route? A court may impose the same orders as those available to the MMT. Moreover, it has the authority to issue sentences of 3 to 10 years in prison and fines between 1 million Hong Kong dollars and 10 million Hong Kong dollars. If I've lost money due to someone else's market misconduct, can I still pursue a private civil action for compensation, even if the government has jailed them? Absolutely. It's important to note that you always have the right to pursue a private civil action for damages, regardless of whether the government has prosecuted the offender or how that prosecution turned out. A government's finding of market misconduct will no doubt assist your case when seeking compensation. However, even without such a judgment or prosecution, you can still take them to court in a civil action to seek compensation for your losses. Is that clear? Bear in mind that a transaction connected with market misconduct is not voided. Even if the other party acted wrongly and you suffered losses, the transaction is not necessarily voidable. Having discussed market misconduct, let's now turn to another potential violation. Unsolicited calls, more commonly known as cold calls. So, what exactly are unsolicited calls? It's when an intermediary, without an express invitation, takes the initiative to approach and contact a client who isn't already their client, but instead of a stranger. The intermediary then induces this stranger to engage in securities and futures dealing. We term this as an unsolicited call. For an act to be regarded as an unsolicited call offense, any of the following elements must be present. Offering agreements to buy or sell financial products regulated by the SFC or offering securities margin financing. Providing profits, income, or other returns from dealing, such as rebates, to induce the client to agree. Put simply, it's about getting the client to make an agreement. Now, imagine casually calling up someone and saying, "I'm Miss Lee, a stockbroker. I'd love to have a meal with you and introduce you to our company." Would this be an unsolicited call? No, it wouldn't. And why is that? In this case, I didn't induce the client to sign an investment agreement, nor am I inducing them to invest. I'm simply introducing our company or perhaps just myself. Or, let's say, I wanted to invite someone I found attractive out for dinner. Such interactions do not count as unsolicited calls since there's no talk of reaching an agreement. They aren't regarded as unsolicited calls. Clear enough? Why are unsolicited calls not allowed? Firstly, such actions could lead investors to recklessly hand over their personal data and money to strangers, risking their privacy. Additionally, investors could be misled by apparently professional analytical reports and company brochures. They might also be attracted by fanciful investment opportunities without checking the offeror's status or background. Thirdly, investors might buy stock without ascertaining the background of the issuer. Fourthly, investors might open an account without taking proper precautions. They may unintentionally be involved in activities such as money laundering. They may also face disputes and litigation due to information asymmetry. In short, regulatory authorities discourage such unsolicited calls to protect investors from uninformed and impulsive investments. Imagine you're a client who received an unsolicited call and then went on to sign an agreement with an intermediary. You might be wondering, what's next? You have the right to rescind the agreement. All you need to do is provide written notice to the intermediary within 28 days or 7 days after the day of finding out about the contravention, whichever is earlier. Taking this step will effectively cancel the agreement. But what if you found yourself trusting the intermediary despite those unsolicited calls? Perhaps you believe they have your best financial interests at heart. Can you choose to keep the agreement? Absolutely. The choice is yours. After all, it's all about how comfortable you feel. Strangers aren't allowed to make unsolicited calls, so how do intermediaries go about their business? Are there certain persons they can approach without violating any rules? Indeed, there are. Intermediaries can freely approach their existing clients. They can also make unsolicited calls to other professionals in the industry, such as licensed persons and registered institutions. Contacting professional investors isn't a concern. Both certified public accountants and solicitors are on the green list. Moneylenders are also receptive to unsolicited calls. Moreover, advising a securities holder about trading the securities they hold doesn't count as an unsolicited call. For example, if I know you have shares in Vitasoy and I propose you trade those shares with our firm, it's not the same as making a random call. Make sense? What methods exist for unsolicited calls? Imagine you're an intermediary. If you visit a client's home uninvited, asking if they'd be interested in buying stocks through you and expecting an immediate response, that in-person visit qualifies as an unsolicited call. Likewise, cold calling a client and saying, "Hello, Mr. Chan, I'm Mr. Lee from ABC Brokerage. Ever thought about buying stocks? With us, you stand a good chance of profiting. What do you say?" If Mr. Chan needs to respond promptly, that phone conversation is an unsolicited call. Are there other forms of unsolicited calls? Any dialogue that requires an immediate reply is considered an unsolicited call. By interactive, we mean any conversation that seeks an immediate response. For example, it's interactive if you're waiting for a quick decision after presenting an offer. Messaging through apps like WhatsApp or WeChat and expecting immediate replies is another form of unsolicited call. Any communication that needs a quick response is considered an unsolicited call. Exceptions to this rule include handing out leaflets, which don't ask for an on-the-spot reaction, and pre-recorded phone messages, radio broadcasts, and computer ads that lack direct interaction unless they instruct the user to press a series of numbers or provide immediate feedback. These types of communication are labeled as permissible communications and don't fall under unsolicited calls, understood? Imagine introducing yourself on a dating app as an investment banker. Would that be considered an unsolicited call? No, it wouldn't. But with so many dating apps offering real-time chats these days, why isn't that seen as an unsolicited call? You're simply letting people know your profession and genuinely looking to make friends. You're not inducing them to invest in securities or futures, so it doesn't count as an unsolicited call. However, if you were to say, Invest in this stock with me now, and you'll get an extra 1,000 Hong Kong dollars cashback. That's an issue. That's because you'd induce others to enter an investment agreement. Got it? We have previously discussed market misconduct and unsolicited calls, which can be illegal. Now, let's discuss improper trading practices. Though not viewed as market misconduct or illegal, these practices breached the code of conduct. So, what might the consequences be? Offenders could face penalties such as license revocation, fines, public censures, or even a prohibition from the securities and futures sectors. While it's worth noting that these breaches don't lead to imprisonment, the absence of such a stringent penalty might still tempt some intermediaries to engage in these activities. What are the improper trading practices? There are mainly 7 types. Boiler room activities, churning, corporate misgovernance, front-running, rat trading, unsuitability. 7. Unauthorized trade. The first type we're discussing is boiler room activities. But what exactly does this mean? It refers to the continuous and aggressive efforts to persuade individuals to invest in exotic-sounding stocks, bonds, futures, options, and other investment products. What channels do they use for sales? Telephone, email, fax, and online platforms. Often, these sellers are located overseas, but even local sellers might push for foreign products. Typically, the sales intermediaries claim that these investments offer very high returns, which most investors are unfamiliar with. Moreover, they frequently pressure investors to invest within a short time frame, often within 3 days or a week, clear signs of high-pressure tactics. Although these investments usually involve overseas transfers, the name of the bank account you're asked to transfer to often differs from the apparent seller. Once you have paid, you will be continually asked for further payments. Fancy an example of boiler room activities? Watch the film The Wolf of Wall Street. It perfectly captures these tactics. Are these activities illegal? Not necessarily, but it might breach the code of conduct. What exactly is churning? Churning occurs when an intermediary continuously executes excessive orders to generate higher commissions or other benefits. This is particularly concerning when a client has already signed a discretionary agreement or committed to certain investment decisions in a fund. It implies that these decisions aren't directly made by the clients, but rather by the broker or investment manager. Such professionals may continuously conduct transactions, placing their own profits above the client's investment goals, experience, style, and best interests. This unethical behavior is known as churning. The third type we'll address is corporate misgovernance. What exactly is corporate misgovernance? It's when the board or management of a company either fails to manage the company effectively, doesn't provide the necessary disclosures to shareholders, or engages in fraudulent actions or misfeasance. We have covered this in Chapter 6, so I won't go over it again. The fourth type we'll discuss is front-running. But what is front-running? Simply put, front-running occurs when, after learning of a client's intended trade, someone decides to trade ahead of that client. Take this scenario for instance. If you're a broker and you discover that your client, ABC Fund Ltd., intends to buy a significant amount of a particular stock, you anticipate that such a purchase will push the stock's price up. Knowing this, you might buy substantial stock before ABC Fund Ltd. moves. Then, when they finally purchase the stock and its price shoots up, you could sell your shares at a profit. What exactly is rat trading? Imagine this scenario. Mr. Chan instructs you to buy HSBC shares for him at $80. Seeing that they're currently at $79, you buy them but don't allocate them to his account right away. 1 minute later, the price jumps to $81. Instead of immediately allocating these shares to Mr. Chan's account, you hold onto them. At this point, you call Mr. Chan and say, "The share price has increased to $81. I know you wanted them at $80, but there was a delay on my end. Do you still want them at the new price of $81? If Mr. Chan agrees, you then sell him the shares you bought for $79 at the price of $81, making a profit. In such cases, we refer to this as rat trading. Clear? So, what's the difference between rat trading and front running? In the case of front running, the broker knows the client's trade instructions beforehand and acts before the client transacts, embodying a know first, act first mentality. Whereas rat trading emphasizes the subsequent operations after trading. They first trade, wait for market price changes, and then determine how to allocate that particular transaction. The sixth type is
unsuitability,
which is also an improper dealing practice. When introducing the code of conduct, we have often mentioned that brokers' recommendations to clients should be suitable. If one blindly provides suggestions without knowing the client's background, investment experience, financial condition, and investment objectives and advises them to invest or trade, this can be seen as unsuitability. These are all improper trading practices, got it? The final type is unauthorized transactions. What does this mean? It means that the client did not authorize you and did not give you this authority, but you still conducted the transaction. This is referred to as an unauthorized transaction. What activities does this include? It involves dealing in buy or sell transactions without client's authorizations, improperly keeping records, wrongly issuing contract notes and statements, or misappropriating client assets. All these are regarded as unauthorized transactions, okay? What is the purpose of the SFC initiating enforcement actions? There are three main reasons. Protect investors, to ensure they do not experience losses due to unfair dealing practices. Ensure the fairness and stability of the market, promoting confidence in the public in the marketplace, and make individuals who have breached the law aware that their actions have consequences and they should be held accountable for their behavior. So, how does the SFC enforce the law? The enforcement proceedings of the SFC include the following three steps: identification, investigation, and taking measures. First, it must be confirmed whether an offense has occurred. If it is confirmed, an investigation will be launched. Finally, based on the result of the investigation, measures are taken to protect investors and the market while punishing the offending individuals at the same time. Are you preparing for HKSI, MPFE, IIQE, EAQE, or SQE examinations? Look no further. At 2C Exam, we have everything you need to succeed. Our comprehensive suite of products and services includes premium online and offline question banks, personalized one-on-one tutorial sessions, tailored group classes, and private consultation sessions. Need assistance with licensing or examination inquiries? Don't hesitate to get in touch with our knowledgeable team. We're always here to help. We're open Monday to Friday, from 9 a.m. to 12 p.m. and 1 p.m. to 6 p.m. You can reach us by phone at 211-09644 or send us a message on WhatsApp at 934-72064. Need to send us a fax? Our fax number is 211-19644. Prefer email? Drop us a line at info@2cexam.com. And don't forget to connect with us on WeChat, HK2C Exam. Choose 2C Exam, your path to exam success. Reach out to us today and let us help you achieve your goals.